Any mention?
Please, Your Lordship.
Yes.
Lordship, I beg to mention item number 8. Conducting counsel is indisposed.
Yubin is not well.
No, Your Lordship.
Oh, what to do?
My lord,
Yeah, objection?
no objection. He's not well, my lord. They have informed.
Okay. 8?
8.
Only 8.
Only item 8, my lord.
As it is stated that the Iron Council is indisposed. After?
1 week, my lord.
It's not 1 week, yes.
Much obliged.
May it please your lordships. Lordship, I beg to make a mention of item number 7, your lordship, as the Leonard DGI is out of station, your lordship.
Dr. Mosika is on the station. Yes,
No objection.
due to unavailability of the Leonard DGI. Yes, after?
After 2 weeks, your lordship.
Yes, matter after 2 weeks. Yes.
Lordship, I beg to mention item number 9 and 10. So conducting counsel, Mr. Upadhyay is not well. So the matter may come up after 2 weeks.
As these Mr. Espudia, legal counsel is stated to be indisposed. This matter after 2 weeks. Vote 9 and 10, same order.
Deputy.
Item number 1.
May it please your lordships. Lordships, rejoinder has been filed.
The matter can be fixed for hearing, my lord.
It's under what provision?
My lord, they have filed the rejoinder, my lord.
The file, okay. Yes, Emmy Ahmed submits that presumption has been filed. Accordingly, as the period is complete, this is a matter for hearing. On so and so.
Also list.
Item number 6.
We have taken steps, my lord. The service report is awaited, my lord, on respondent number 1, my lord.
What case is this?
This is for continuation of delay of 22 days, 17 days delay, my lord.
Days, 22 days. I guess a quick look. Office note indicates that the service on the respondent,
Respondent number 1, my lord.
respondent number 1 is incomplete. You want to obtain status?
My lord will obtain status, my lord.
MS Adatal and legal counsel, please get out to obtain status and to file affidavit of indicating service. At least up to 3 weeks. Yes.
Any mention?
May I please, Your Lordship? Your Lordship, I beg to mention item number 17, Your Lordship. Here the conducting counsel, Mr. A.G. Momin, is indisposed, Your Lordship. So I pray that the matter may come up after 2 weeks.
Lordship, number of adjournment have been taken. Sir,
What's the matter about?
It's an arcing matter, Your Lordship.
Because the thing is that he's indisposed. What to do?
as your Lordship desire, but I just want to bring to your Lordship notice
Yes,
that
a mention been made on behalf of Mr. A.J. Momin, the Army Counsel, who said to be indisposed. Stop Mr. V.G. Chandal appearing for the private respondents, however, voice objections. On the ground that the matter has been repeatedly adjourned. So, if I be as it may, in the interest of justice, due to the be as it may, however, due to the unavailability of the counsel, is the matter after
2 weeks, Your Lordship.
next time is okay.
Yes, Your Lordship.
Yes.
Similar prayer for item number 26, Your Lordship.
As the counsel persisted, we dispose this after 2 weeks. Yes. No objection.
No objections, Lordship.
Yes.
Much obliged.
Lordship, I beg to mention item number 24, Lordship, of the main list, Lordship. I'm praying for a week's time, Lordship.
No objection.
Lordship, it's connected with those other matters concerning VC, Lordship. Lordship, the matters are specifically listed today, Lordship.
Well, then no
I have objections.
Maybe the Lordship. Lordship, the matter can be listed on the 6th, Lordship, since item number, if I can take your Lordships to the remarks in the causes, Lordship.
Remarks in the causes where?
Yes, Lordship. Along with WPC 429 and 433, Lordship. 433 will be coming on the 6th. It can be taken up on the.
Because
on
these are
6th,
interconnected
Lordship.
matters, Lordship, with regard to the VC.
These are connected matters,
Other
Lordship.
villages, Lordship.
Lordship, these are
Not
regarding
so very
verification of the job card holders, Lordship.
Not concern the same village,
No,
Lordship.
we'll take it up when it comes. And if it's, we post it somewhere, we'll do it.
Lordship.
Yes.
May it please your Lordship, I beg to mention item 20. The conducting counsel is on sanction leave, Your Lordship, so I pray for 2 weeks' time, Your Lordship.
My Lord, item number 20 is all connected with item number 18, 19 in the hearing list as well as in the order item number 2 and 3. So, my Lord,
2 and 3?
Yes, my Lord. If Lordship will see item number 19. Yes, my Lord. These are all pertaining to the same issue.
Let adjourn it. You wait, let it be called out.
Okay.
Yes.
Please, Your Lordship. Lordship, I beg to make a mention of item number 18, Your Lordship.
18?
18.
What do you mention just now?
Yes, my Lord. These cases are all connected. So, at the orders time, my
yes,
Lord.
that time when the matter is taken up, you
clarify.
mention how it's connected and why it's connected. Yes.
It is.
Yes.
It is.
Lordship, I beg to mention item 22, Lordship. Lordship,
Yeah.
in this matter, we just received a scheme, Lordship, general pension scheme.
What scheme?
The general
last
pension
time we
scheme.
were asked to give that scheme. Regarding that scheme, it provided that there is a criminal case pending.
What scheme?
This is a pension scheme.
Pension scheme, Your Lordship.
This pension scheme which is governed by, which governs the petitioner. So when the matter came up hearing this copy, they said that this copy was not there. However, it was annexed in the affidavit. Still
Okay, this matter, Mr. Rope.
Yes, Your Lordship.
That the matter is after 2 weeks.
Lordship, let the matter be.
Yes.
On the 16th.
On 16, Your Lordship.
16, because there are some fixed matters. So again, I
Yes,
just
it
have
depends
to
on
come.
court master.
Well,
If the two matters are 16, then rule will still 16, yes.
well,
Highly obliged, Lordship.
Let's on the prayer council for the petition, this is the matter also.
Please, Your Lordship. Lordship, I beg to mention item number 21.
Yes.
Item number 21, Your Lordship. Item number 21, Your Lordship.
Yes.
I believe this matter may come up on the 26th, Your Lordship.
Why 26?
The conducting counsel is having some personal difficulty.
Oh, why 26th of June?
Yes, Your Lordship.
You're not going to give deal. Who's the conducting counsel?
Elal, Your Lordship. Your
Who's
Lordship.
Elal?
He's from Ghati, Your Lordship.
We won't adjourn today, argue it then.
Let it come after 2 weeks then, Your Lordship.
Don't ask for dates for outside councils.
Your Lordship.
I'll request for petitioner after 2 weeks. Then all local councils also have the right to ask for dates also.
Lordship.
The same equal treatment. Not because you say that someday I'm going to come to Shillong on that day. No. Come and argue the matter first, then we'll adjourn it. Yes.
Lordship.
Lordship.
Lordship, I beg to make a mention of item number 23, Your Lordship.
Yes. Where's Mr. Deb?
Your Lordship, I couldn't find him in the... No, Your Lordship. I'll inform him.
Because he's not available mostly. Yes.
Lordship, similar prayer for item number 29 as well, Your Lordship.
Yes, 29?
Yes, Your Lordship.
You for the petitioner? You have no objection?
No objection, Your Lordship.
Yes.
Much obliged.
2 weeks, yes.
May I please, my lord? My lord, I want to I beg to mention item number 16, my lord.
Number?
16.
Yes. On whose behalf?
I'm for the respondents, Your Lordship.
Who's the petitioner?
Petitioners Mr. SD and SD.
I'm prepared for the petitioner, Your Lordship.
Objection?
No objection, Your Lordship. No objection.
You have for respondent number?
No, she's with me, Your Lordship.
Oh. Yes, okay. On the request of so-and-so. This after 2 weeks, yes.
Pleasure.
Much obliged, Your Lordship.
Supplementary list item number 1.
Please, Your Lordship. Item 28, my lord. Item 28, my lord. MTC matter, my lord. With regard to the 5th pay commission, my lord.
With regard to?
5th pay commission, my lord.
Yes.
My lord, the as per the affidavit filed by the state and the MTC, the decision is yet to taken on the releasing of the fund, my lord. So they've taken a decision, the matter would end, my lord.
Because the recommendations of the 5th Pay Commission relating to pay revision has been implemented by the state government with effect from 2017. The corporation has decided to implement it from 2019. They are aggrieved with that particular date. So they wrote out several representations to us and the union also visited us. Now, because of this situation, we've represented the matter with the state government. If the state government decides to give them any kind of relief, we are okay with it. But we've taken a decision, the board, that the date of implementation will be from 2019.
Yes, my lord.
So you want parity also?
My lord, yes, my lord. My lord, prior to 5th Pay Commission, 4th Pay Commission, 3rd Pay Commission, well, exactly because the MTC is following the pay structure of the state government.
Well and good, but the thing, well and good. But the thing is that, you see, they are an autonomous body of population,
yes,
correct?
ma'am. Yes, ma'am.
It's up to their own decision when they adopt it from when. You agree with that, we'll hear it.
My lord,
if you say that it hinges upon the...
They have not denied it. They have written to the state government.
It's not a question of denial. It's a question of ability of... It's a question of the financial implications on the part of the state.
Yes, my lord.
So the state agrees to give them that benefit, we are okay with it.
Agreed to give from 2019.
So what, we'll close the matter, what do you do?
My lord,
they can await the decision of the state government.
Yes, my lord. Since they filed the affidavit, in their affidavit, the state has stated in that affidavit that decision is yet to taken on the releasing of the fund, my lord.
Mr. S.K. Hassan prays the matter be adjourned for 6 weeks to win a decision of the state respondents with regard to the sanctioning of requisite funds for implementation of 5th Pay Commission.
Yes, ma'am.
From the year 2017. Yes. Yes, accordingly.
Obliged.
Highly obliged.
Item number 1.
May I please, Your Lordship? Your Lordship, you can pass the matter for tomorrow, Your Lordship. Mr. Nongri is still on legs. Mr. Nongri is still on legs, Your Lordship.
You can move it. What's the matter about?
Your Lordship.
You have any interim orders?
No, Your Lordship.
Then you're not doing interim orders. Yes.
Your Lordship, this is a matter, Your Lordship, where there was financial fraud committed by an employee of the bank, Your Lordship, where she had siphoned an amount of almost 2 crores and 53 lakhs from the petitioner's account, Your Lordship. So we are here before Your Lordship, holding the bank, vicarious liability for the fraud.
Vicarious liability?
Yes, Your Lordship, for the activities conducted by the employees of the bank, Your Lordship.
What's happened to the person then? Who's the person who has defrauded you?
She was...
You've made a party?
Yes, Your Lordship.
Number 7?
Yes, Your Lordship.
Now what happened with the criminal proceedings drawn up against her?
We have filed an FIR, Your Lordship, but
And what happened
investigations
to the criminal case?
still pending, Your Lordship.
Is pending?
Yes, Your Lordship.
Yes? And now what is seeking? You're seeking?
For refund of the entire amount, Your Lordship.
By writ. Who crores 53 lakhs? Now the FIR was lodged when?
We have launched several FIR, Your Lordship, in August of
FIR was?
August of 2024, Your Lordship.
August 24.
Yes.
We'll issue notice that Mr. Apasanti and the petitioner issue notice Mr. Yar Khan
123.
Acceptance behalf of respondent 123. Notice to issue to the remaining respondents within 3 days. It is submitted by Mr. Pasantia that the matter concerns defrauding of bank accounts of the petitioners to the tune of 2.53 crores by the respondent number 7, for which they seek appropriate relief before this court. This after 2 weeks for instruction the affidavit.
Item number 2.
Yes.
May it please Your Lordship. Your Lordship, I came before this Honourable Court for a relief that the petitioner is being debarred from attending his exams, his sixth semester exam, his final exams.
Sixth and final semester.
Yes, Your Honor.
Yes. That was mentioned yesterday.
Yes, Your Lordship.
Yes.
Your Lordship.
What grounds is it denied? Attendance.
Attendance, Your Lordship. Low attendance is due to my sickness, Your Honor. He's ill. The petitioner is ill. Your Lordship, the commencement of the sixth semester starts on the 3rd of Feb 2025. But however, Your Lordship, on the 31st of...
It runs from 3rd of Feb to... and it ends on? April.
Last week of April, you know.
February to April.
Yes, Your Lordship. So, Your Lordship, on the 31st of January 2025, the petitioner has some pain in his lymph nodes and his abdomen. And thereafter, Your Lordship, he went to Bethany Hospital for treatment. And on the 4th of February 2025, he was properly diagnosed with this disease, chronic necrotizing lymphadentis secondary to tuberculosis infection. As such, it's in annexure number 4, page 21. Acute on chronic necrotizing.
You need to read that, fine. Yes. Tuberculosis, yes. You applied for leave.
Yes, Your Lordship. Yes. And thereafter, Your Lordship, on the 28th of... It's only on the 28th of Feb I could inform my college formally, yes, along with the medical certificate. Medical certificate is in page 24.
60 days.
60 days, Your Lordship. So thereafter, Your Lordship, from time to time I've been visiting my physician for continuous checks because I don't want to miss my classes.
Attendance, what percent?
57%, Your Lordship.
57?
Yes, Your Lordship.
47% or 47%? Out here, page 37.
Yes, Your Lordship.
47 or 57?
But after recalculation,
57.
It has turned out to be 57%, Your Lordship.
So you have to have at least how much?
70%.
70%.
As per.
Yes, who's appearing for the college? And so where they disallow you? Where's the order?
There's no order. I'm not allowed to. On page 29, annexure number 8. On top it's written it's not allowed.
This is by principal?
Yes, Your Lordship.
Over 50% and yes, Mr. Chakravarti. You have been with the college.
My lord. My lord, there is, firstly, my lord, the first point which I would raise before your lordship is that Bar Council is not made a party in this case. My lord, it's an interpretation of a rule of the Bar Council, but Bar Council is not made a party. Now this, my lord, renders the petition a little somewhat defective, my lord. Secondly, my lord, they are relying on the judgment of the division bench, by which, my lord, the discretion has been left with the principal. Discretion, my lord, that is at page 41, 42, I think. Hmm? 37. The judgment is from page 37.
When's the exams?
Next week, Your Lordship. 11th of June. That's why there's urgency.
I would submit that we may be allowed. Milord, we may be allowed to suffer. Milord, because here, Milord, in this case, Milord, there is no, he was never hospitalized.
No, but once you have tuberculosis, you can't go and visit other people. The thing, it's contagious.
It's a serious ailment, Your
Once you
Lordship.
have tuberculosis, either 40 days or 60 days.
Milord, that 60 days rest, Milord, that was also initially not produced. That medical certificate was also produced as an afterthought later on. And well, I would submit that we may be allowed to file a reply. Submit.
Yes, reply. What about but otherwise he's a
Yes, Your Lordship.
good student.
Yes.
He doesn't have any back
I'll
papers.
just point out, Your Lordship. In the first semester, he secured 89% attendance. In second semester, it's 85.9%. In third semester, 82%. Fourth semester, 73%. And fifth semester, 78%. And overall, he
So that means it's
cleared
not
all
a
his
question of
exams.
he's
It's not deliberate, Your Lordship.
usual defaulter or doesn't attend classes. Yes, and Mr. Sen, you're representing.
My lord, here your lordship will appreciate one thing, my lord. Bar council may have a rules. There is rules. Now, so far, my lord, conducting of this semester 3 years course, the exam is conducted by the university, NEHU. Now, NEHU has a set of rules. Now, so far, my lord, this is concerned, my lord. We have, my lord, regulation RC 17, my lord. I'm just submitting, my lord. RC 17, my lord, rule 3, regulation 3. It clearly says the student shall have attended each paper, 75% lecture, seminars, tutorials, moot court, practical training course taken together. Provided, my lord, there is a proviso, in deserving cases for reason to be recorded, relaxation of attendance up to maximum of 5% could be granted by the head of the institution. So relaxation, my lord, this is a subordinate legislation, up to 5% is permissible.
So if
Now,
it
can we,
get at least 62.
my lord, is 57%.
So if relaxation of 5%, that means plus 5%.
70 minus 5, Milord. 65. I mean, in that judgment which is being relied upon, Milord, this rule of the university was never discussed.
This has never been referred.
This was never referred to.
Why was it never placed?
This was my lord, they have only relied, my lord, on these parts of regulations.
Who has been Bar Council regulations?
They relied only the BAR's regulations, Your Lordship.
Only the bar regulation was challenged, Milord, in that case. I mean, in
That was
the
not
earlier
formally
case.
challenged, only referred to.
Your Lordship,
I
this.
remember the other case also, I mean, a single bench is allowed, I think.
Right.
Because he's a habitual absentee, I think.
No, not only that, Milord, the rule itself is very clear. Now, Milord, of course, now this rule has been interpreted by the Honorable Division Bench, but the rule of NEHU has not been considered. That, in a way, Milord, makes the judgment par inquirium. It makes the judgment par inquirium because all the aspects.
Is the matter still pending or disposed of?
That matter is
Disposed of. They have not appealed this matter.
My lord, we will appreciate one more thing, my lord. College affiliated, my lord, they are strictly bound by our rules and regulations. Now, our rules is very clear and categorical, my lord. This is not under challenge, my lord. Now, we cannot circumvent this rule, my lord, and grant additional relaxation. We cannot allow that. That's my humble submission, my lord, is not permissible.
Milord, we will submit the affidavit.
And we don't have any proviso for exceptional circumstances?
No, it's not there.
That's why, my lord, we came before this
No, it
honorable
would have
court.
been otherwise if they had challenged the rule oppressive or otherwise. That's a different thing, my lord. This is not under
You have
challenge, my
to
lord.
supplement your petition.
And college is acting only as per the rules, my lord. And they are bound by it. And it further say, my lord, if the college, my lord, violates, the affiliation will be cancelled.
Yes. Take down. Mr. I smell the counsel the petitioner. Issue notice. Mr. S. Chakravarti, the senior counsel. With who's with you?
Ilalu.
Mr. Ilalu is present, except those will be is present behalf for number 1. And for the remaining respondents, and the names are represented by Mr. S.N. with M.S. Ibla. The grievance, the writ petitioner, who is stated to be a 6th semester student pursuing a 3-year LLB course in the Shillong Law College, which is affiliated to the Northeastern Hill University, is aggrieved with the refusal of the college authorities to allow him to take the 6th semester exams on account of deficiency in attendance. Stop. It will be submitted by Mr. Isomena counsel, the petitioner, that the non-attendance or non-attainment of the requisite attendance was due to the fact that the petitioner was suffering from tuberculosis, which was detected in the first part of February.
Yes, Your Lordship. 4th.
The council has also drawn the attention of this court to the certificate annexure. Where's that one? 29?
Annexure 4. Page 20. Page 24.
Drawn attention to this court to a medical certificate wherein the petitioner had been advised, recommended 60 days medical leave. So, the council first submitted that from the 1st to the 5th semester, the writ petitioner has very good attendance, and it is not a case where he is a habitual absentee, but that the same was caused by circumstances beyond his control. Stop. It is then submitted that as the exams are scheduled
11 of
commence from 11th of June, and view of the denial of permission to sit for the exams, he has been compelled to come before this court by way of this application under Article 226 of the Constitution. Stop. Next paragraph. Ms. Esther Gorti, learned senior counsel for respondent number 1, has at the outset submitted that though reference is made to the Bar Council rules, yes, the Bar Council has not been arrayed as a party respondent, and as such, on this ground, the petition is defective. Stop. What's your further submission?
And then principal has been exercised his discretion fairly, because as per the judgment relied upon by the division bench, the discretion is left to the principal, and he has exercised his discretion, because in this case there was no hospitality.
That though reliance has been placed by the petitioner on a judgment of this court passed by division bench in a similar matter, that is WC number 74 2024. Discretion, however, was left to the principal, who in the instant case has exercised the same by not allowing the petitioner to sit for the examinations. Stop. Mr. E further please be allowed to file a reply within
Short,
2 weeks.
short period will do.
Within 1 week. Yes, next by Mr. SN, that is counsel appearing for the NEHU, has submitted that the college in question is affiliated to the university, and it is the university that conducts and regulates the examinations. He submits that the prescription or the regulation for 3-year LLB degree course bracket semester system has certain prescriptions as given in this is regulation number 3.
17.3. RC 17.3.
In regulation 17.3. With 75% lectures, but then they have 70%. As per the college prescription, 70% of out here prescribed 75%.
As per the Bar Council rules, 70%.
30%. Problem? Problem? Which however provides that in deserving cases for reasons if recorded, relaxation of attendance can only be up to a maximum of 5% to be granted by the head of the institution. Stop. He further submits that the rules, the regulation 73 have not been placed or challenged for this court. And aside on the ground also the writ petition is incompetent. Where are the Bar Council rules? Where you took it?
Annexure number 9.
Rule 12.
Yes. Rule 12.
I've heard the council of parties also examine the materials placed. It is seen. It is noted as submitted that the petitioner all along from the first to fifth semester has maintained adequate attendance and also is a good student.
Yes, Your Lordship.
How do we see that? I have not seen its marks.
Its marks, it's in.
Okay, that has problem. This scene is noted. It is no pom the scene or pom. The attendance of the petitioner has been adequate and above the percentage required as prescribed by the Bar Council of India rules, and that's only the 6th semester, which is attributed to his illness, that the said attendance falling short, and as recorded, as seen from the records, is 57%. Next, stop Rule 12 of the Bar Council of India rules of legal education has prescribed that a minimum attendance of 70% of the classes held in the subject concerned. So let's the subject concerned. Stop. And accordingly, it appears by the operation of this rule, the respondent number 1 would not condone the shortfall in attendance to allow the writ petitioner to sit for the examinations. Next paragraph. This court also notes that, as earlier submitted in WA number 74 2024, this court division bench, where's the observation? Allow me to sit.
Page 41.
By order dated 6/5/2025. Where? Where is it? You can sit.
Page 41, Lordship. Last para.
The paragraph numbers you say, huh? Yeah. Problem there.
Forty-one and 42, my lord.
Yes, at page 4, page 5 and 6, there's no paragraph given. At page 5 of the judgment had held as follows. Stop. Approval of the order of the vigilance of this court shows that it has been held that the rule 70% does not cover extraordinary circumstances such as illness, and that the administrators of the college are to consider each case on its own merit. Stop. In the instance case, the facts also being similar, as much as the petitioner is stated to have contracted tuberculosis, and also coupled with the fact that he has been a regular student. Accordingly, in line with the judgment of the division bench of this court, in the interim, it is directed that the respondents allow the petitioner to sit for the 6th semester exam, which is to commence from 11th of June 2025. Top. Next paragraph. Liberty is also granted to the petitioner to make suitable amendments in the petition. List after 3 weeks for affidavits for the instructions.
Oblige, Your Lordship.
Oblige.
Daily list item number 1.
My lord, here in this case that the bank has annexed two document issued from the Treasury Lordship. They have given the clarification, Lordship. If that the reason which they have assigned in that two documents, Lordship, if they with that same reasons, if they write a letter to the pension sanctioning authority, that will serve the purpose, Lordship. My lord will kindly come to page 6 of the affidavit filed by the bank, Lordship. They have given the clarification, Lordship.
Page?
Page 6 of the affidavit filed by the bank, Lordship. That is respondent of 4 and 5.
Where at?
Respondent of 4 and 5, Lordship.
Yes.
Annexure 2, Lordship. They have given the details here, Lordship, from the Treasury. Why they have paid and why they cannot issue the LTA, Lordship. And second page, my lord will find the details of the payment made through the Treasury, Lordship. If these two letters they can forward, that will suffice the purpose, Lordship. They have given the clarification why they have paid, and that is exactly are asking from the Treasury, Lordship.
My lord, look at the letter. In the writ petition, it's a different case, my lord. Now, in the writ petition, the petitioner has impugned letter of the AMC, my lord, and they are the one who is asking for clarification. I represent the treasury, my lord, and the treasury has also said the same. In PPO, everything is there. My affidavit is also the same with the bank, my lord. So the actual authority who has actually been delaying is the AMC, my lord, not the treasury. We have been supporting, and my lord, the documents enclosed in the State Bank affidavit is the same document enclosed by us. It was my document that has been enclosed in the State Bank of India's affidavit, my lord.
That is why I am saying, Lordship, whatever they have assigned.
And the clarification sought by the AMC, my lord, is regarding how the petitioner hasn't paid. And the PPO is very much clear. Why was the PPO not sent by the petitioner?
That is, they have clarified in the letter. Same letter they can forward to the...
clarified to the AMC, my lord.
The letter was issued to the Treasury, Lordship. The AMC has directly written letter to the AMC, to the Treasury. They are not responding to the letter issued by the AMC, Lordship.
The entire issue is the sanctioning pension authority is AMC, my lord. My friend is harping on the SBI or the Treasury will not be a solution to the pensioner, my lord, family pensioner.
The query was how was pension paid all
Yes,
along.
Lord.
My lord.
And the only thing that he's saying is that the answer to that query lies in his correspondence.
We have, my lord, we have corresponded.
That's already,
we have
that's the only
corresponded.
thing. So for Treasury also, like the only thing is to communicate the same thing.
We have done it, my lord.
But
We have done it.
They have not done, not a single letter they have issued to the AMC, Lordship. My lord will kindly find page 24, Lordship. Why my friend is saying
Don't
that...
get excited, it's fine, just relax. Yes.
24, page 24, below, down, Lordship.
Yes.
Down, Lordship. Last paragraph. Page 24.
Yes.
It is intimated that this office asks the clarification and page 24, Lordship. Again, this was directed to the Treasury, Lordship.
It is intimated.
Page 24 and exact 10, Lordship. Below, down. Request forward fresh so to this office as the widow of the deceased soldier facing financial hardship. It is not that they are not giving or sanctioning the pension. They are asking clarification. You just give me the clarification, and that clarification has already been given in the letter which I have cited, Lordship. The same clarification they can give to the AMC.
Direct the AMC to take cognizance of that.
Yes, Lordship. That will suffice, Lordship.
Yes, my lord.
That will
That
suffice.
is the solution.
Yes.
Who's appearing it? AMC is a party?
They have not made them a party, my lord. That I have been
I'll just
from the first day.
I'll just
implement them now after the matters come to the last legs.
My lord, why I am saying, Lordship, even if they can write a letter directly to the AMC.
If they made a party review directions here, will be done in.
Then
Mr. Sheikh.
I'll just.
Mr. Sheikh prays that we are allowed to file a application of treatment of the Army Medical Corps.
2019 July. Since then, my lord, the paper has been given to SBI. So directing the Treasury will not be suffice the entire case, my lord. And the document is so it is between SBI and the thing.
Item number 2.
I'll direct that. Meanwhile, you pay a pension from your pocket.
And your lordship, in this case, SBI is just a medium for the.
Just yes.
2, 3, 19, 20.
Yes.
Mate, this is your lordship. Lordship, item number 2, 3, 19, and 20, your lordship.
Just 1 second.
Similar matter, lordship. I'm sorry. Item number 2, 3, 19, and 20, your lordship. These are
similar. 2, 3,
19, and 20, your lordship.
Similar matters.
Yeah, these are similar matters.
Okay. 19 is already in the hearing list, lordship, and 2 and 3.
Number 2, 3,
your lordship.
And 2 and 3 complete.
Lordship, on this 2 and 3, lordship, we have already taken fresh steps as per your lordship's last order, lordship.
So what happened?
Lordship,
what's going through whether that respondent is already appearing in other cases here?
No, lordship, because in 444, lordship, in item number 2, lordship, there is we are yet to serve notice only to respondent number 7. we have done in the last occasion, Lordship. We have posted through
Your head of personal service.
AD, Lordship, because they're not accepting, Lordship, through AD cards, Lordship. And then in the item 3, Lordship, we have taken fresh steps to the respondent number 4, 5, and 6.
In these cases, I think we have to send notice by enforcement authorities. I think they refuse to accept personal service. 7 is
Open the file.
national property.
And NCTE, Lordship.
Refuse to accept personal.
Because we have served to the local council, Lordship.
What is represented by whom? Personal notice to a body.
Union, Lordship.
No. See, you just said National Council Teacher Education.
Yes, Lordship. Because earlier.
It has to be a human head of this thing. It's not a.
Yes, we have already.
No, who's the person who will receive notice and answer? When you said a vague.
No, Lordship, because in the earlier occasion, Sir Mozika was appearing, Lordship.
No.
He was submitting that
Where's
he cannot
the
accept.
NCT here?
It appears the address also is not complete, Your Lordship.
Yes.
Just Government of
How will they accept?
New Delhi, Your Lordship. Statutory body, Government of India, New Delhi, Your Lordship. It's incomplete address, Your Lordship.
It's like addressing something to Meghalaya High Court. Who will receive it? That's Registrar General or someone.
Also, as far as my instructions.
You said personal notices, personal service will refuse. National they refuse.
No, Lordship, I was under the impression that Sir Mozika used to appear, Lordship. So we thought of serving directly to him, Lordship, but then we found out that we have to serve them in through post. So we have done that.
Correct the address. Mr. Tidakar submits that praise he went out to
445.
Ascertain the correct address with regard to number 7. Sorry, Ms. Mozika or Mr. Tidakar says that may be allowed to obtain necessary particulars of the person who will represent respondent number 7 steps upon the said person, upon the said office.
Yes.
Yes. 2 weeks time allowed. Otherwise, it won't go anywhere, this matter.
Yes, Lordship. We'll take instructions, Lordship.
You take instructions, you find out from website.
Yes, Lordship.
You can't take steps on in the air like that. Same issue here.
No, three is perfect, Your Lordship. The parties are codicil is all right, Your Lordship.
We have taken step for the second time, Lordship.
This also step is also part of the party law. Right? SCRT also.
Okay.
4, 5, and 6.
Number 4, insufficient address returned.
Please check the array of parties.
What are you going to do?
Also here, because we have given the state of Assam represented by its chief secretary. Respondent number 4.
Address insufficient.
This is the address. This is the address we found. Also, as per the.
How are you going to resolve this issue?
Also, as per the status.
Insufficient address means they couldn't serve it on the address that you've written.
No, Lordship, in the first step is shown that it's already delivered. Lordship.
On respondent number 3?
Yes. Respondent number 4. 4, 5, and 6.
Where is shown is delivered?
Lordship, in our service affidavit is there. Lordship, we have framed.
Where is that service affidavit? Sorry.
Can you see annex page 10?
Who wrote this address? Who's highlighting this one?
Lordship is our colleague only, Lordship.
Who's your colleague?
Lordship, that I will have to ascertain, Lordship.
You see what's written here?
It's one of us only, Lordship.
See what's written here. See, if you all junior counsel, you should have to be very careful. To the state of Assam, written here.
That, Lordship,
Block C.
I'll have to
Nothing is
rectified.
insufficient. You haven't written chief secretary there. What do you? We don't have the whole classes here in this court now on how to take steps, how to address correct people.
My apologies, Lordship. This address is not as per the cost title, Lordship. Here.
Then whose fault is that?
Lordship,
They said that we received.
it is our fault, Lordship, and I deeply apologize, Lordship. We'll take fresh steps, Lordship.
Please allow to take fresh steps.
If Lordship have our affidavit, this service affidavit at page 10.
We're not recognizing that anymore. It's come back.
Yes, Lordship. But in the first occasion, Lordship, it was already delivered. It's showing. The status is showing, Lordship.
See, Mr. Idakhar submits that offence so however, there's no appearance we have today. The petition, this direction of the court is what?
Yes.
In order 1905, the
Yes,
petition to take fresh steps.
That is fresh step.
Then?
Lordship, this was the first step, Lordship. We'll take steps in.
The service report on respondents 5 and 6 is not returned, and with regard to respondent number 4, the address is insufficient. Mr. Tidakhar to ascertain the correct address has also stated of service upon correct address respondent number 4 and to obtain status of service on respondent 5 and 6 just after 2 weeks together with
Item 19.
And 20.
19 and 20.
just stuck in service and
Job lines, Lordship.
get together with that. 1920, we take it up now.
Lordship, we'll list it together, Lordship. 1920.
One matter can be decided,
Yes.
not the final hearing matter, Lordship. So the other matters will become in front of you.
1920 was 1920.
Yes, 1920.
Yes.
Your Lordship, for 20, I'm asking for some time, Your Lordship.
Why?
Senior conducting counsels on sanction leave, Your Lordship.
19 I'm appearing in 19.
Structures?
No, Lordship, because this matter, Lordship, will have to address, Lordship. We'll address the court, Lordship, accordingly.
Okay, what to do? Stuck in quicksand. Yes.
List them
We have
together.
to do it yes, together with this.
Obliged, Lordship, obliged.
But you take correct steps. I mean, you address, make sure you write the correct address.
Absolutely, Lordship. Deeply obliged, Lordship.
Item number 4.
I may be given some time, my lord, to file my rejoinder to the affidavit filed by my lord, respondent number 3, my lord. And
Respondent number 8.
oh, sorry, respondent number 8, my lord. I may be given
Number
some
9.
time to file
Number
my
9.
8.
9.
Oh, sorry, 9. So far as 3 to 8 is concerned, my lord, the service is already affected, but they have not been represented till date.
So we'll go ex parte against them. Yes, today also no appearance.
But, there's a small
respondent 3 to 8. Yes?
There's a small development, my lord, insofar as the grievance against respondent number 3 and 4 is concerned. My lord, it is already met because, my lord, they have defreezed my account. After my lord, Tamil Nadu 7 and 8.
Okay.
So my grievance now remains only as against, my lord, 3, 4, 5.
So you want to appear, will go ex parte.
Let it go ex parte, my lord. I'll bring on record what action they have taken, my lord.
What about the rejoinder to number 9?
My lord, I may be given some time, my lord.
Mr. S. Thapa prays that he be allowed further 1 week, 2 weeks and for the joint after to the after of the respondent number 9. Prayers allowed also submitted that though notice has been effected upon the respondents 3 to 8, there is yet to be an appearance on their behalf. He prays that the matter be heard ex parte against the respondents of what are you, the other submission? You said that is
My lord, insofar as the grievance against my lord, 7 and 8 is
respondent number 7 and 8, it is further submitted, no grievance
remains, my lord. They have defreezed my account.
as they have frozen the account of the petition and stuff. Accordingly, these submissions the instant matter shall be heard ex parte against the respondent 326. Yes. Just after
2 weeks, my
2
lord.
weeks for your life.
All right.
Item number 5.
Her ex-party, first her ex-party pass number.
Little more time for filing counter.
Your Lordship, may I please, Lordship?
1 second. This is on fructuous.
Yes,
Yes, Your Lordship, I've taken instruction and let this
By the
matter
time
be
we file
closed.
affidavit, all in fructuous, Mr. MS Aliyah from K. Bernard Counsel for the petitioner submits that on instructions, or she submits that the matter is to be infructuous. This matter stands closed as being infructuous, yes.
Much obliged.
Item number 6.
Disposed and disposed of.
May I please, Your Lordship? We have filed the adjoinder, so this matter may be posted for the hearing, my Lordship.
Lordship.
In
We have
fact,
gone
we
through the
disposed
affidavit.
of also. Your
Yes,
Lordship.
because there's nothing. The government also very clear in their affidavit. They have clearly stated that that petitioner have resigned. After the resign only, the BDO have conducted the fresh election. That there's nothing remain, Your Lordship, because it's
Where's your Argy counsel? You are Mr.
Yes, I'm
Mr. Sheikh is there, I think.
No, say.
SW Sangma.
You are?
I'm SW Sangma, my Lordship.
The first time you're appearing?
Yes, my Lordship.
Okay, list after 1 week. As is submitted by the counsel with the respondents, then the matter seems to be infructuous. The matter has not
Can be disposed of. Your
the matter is
Because it's
can be disposed of this stage only. Ms. S.W. Sangma prays that we take up to 1 week due to absence of the Argy counsel. You who's Argy counsel, you bring them next day. This up to 1 week. Yes.
Hello, Black Lordship.
Much less Lordship.
Orders. For further orders.
Item 7.
Give to everyone.
in this case, Your Lordship. In this case, Your Lordship, the state has filed their affidavit.
I'm praying for rejoinder, Your Lordship.
You're praying for?
We are together, Your Lordship.
Awesome to pray for about 2 weeks' time. Before I joined the is this after 2 weeks.
8.
Allowed 2 weeks time for the joinder.
Item number 8.
Lordship, in item 8, the state has filed an affidavit whereby they have conducted verification upon the bogus job cards, Lordship. However, there are 26 job cards that required verification. Out of 26, only 13 has been conducted, Lordship, as per the report. So they'll require to complete the verification.
My lord, verification process will take some time, my lord. It is undergoing. And
only 13 job cards you need?
My lord, even job card holders, they're not cooperating, my lord, in the verification process, my lord.
Strawberry Bari.
Strawberry Bari.
Number 6 is whom? One of the 6?
6 is the BDO, Lordship.
File, affidavit file.
Yes.
So what do you want now?
So, Lordship, if they can complete the verification.
Praise was allowed. Praise that for the time we allowed for verification of job cards. Praise allowed. This after 2 weeks. Yes.
Then in the other item, Lordship, at item 12, concerning the same VC, Lordship. In item 12, what they have done is, Lordship, because there's an interim order passed by this court in item 24 to stay the election, Lordship. Now what have they done is they have constituted a temporary PEIC, Lordship. Right? Lordship, my prayer is that, Lordship, there's no, since if the state completes the verification, Lordship, then perhaps an election should be conducted.
Listen together with them, let them complete that.
Lordship.
Just the 2 matters. 12 and 24 together with this one next day.
Lordship, there's an interim prayer, Lordship, in item 12. Because now the temporary constitution of the PIC was not done as per the requirement, Lordship.
We're not going to go there now. This is a mess, this piece of villages.
My lord, only instead of 2 weeks, if we can be given one month time, my lord, so that we can complete it.
There's some urgency because we won election also,
Lordship.
Lordship.
Now, but it's only problem.
We won election also, Lordship.
We can't have elections now. Monsoon is very heavy in these areas.
Item number 12.
I would like to find my affidavit also on that.
Where?
Item number 12.
Okay. You're appearing for respondent number?
Yes. I'm the cavator in item number 12.
She's appearing for
even a read respondent, cavator
7,
and
Lordship.
when you have been served. Yes.
Respondent 7.
Number 7.
Item 12, my lord, we have to file this affidavit.
Yes, item number 12. 12. Mr. N. Sinkon, we have respondent's number
1 to 7. 1 to 6.
Then M. Cloud, we have number 7. And who are the others? Pray for allowed for a 2 weeks time to file affidavits. And 24 is complete.
24 completings are complete.
So 24.
We've already filed a counter which includes the.
Already in the hearing list, correct?
To verification, Lordship.
In hearing list. Then
Lordship.
Item number 9.
Yes.
May it please your lordship. In this case, my lord, government has on last occasion government has filed an affidavit in opposition, my lord. My lord, I have just received certain instruction, my lord. The affidavit is under preparation, my lord. I need a short time, my lord, to file the affidavit. 10 days time. 10 days time, lordship.
In fact, your lord, I'm sorry, your lord.
Yes.
In fact, your lordship, we have filed the affidavit, your lordship. We are open to
whatever, my lord. I'll place
settlement of the dispute with the Nehu, your lordship. Because we need, your lordship. It is for the public good of the state, your lordship.
Just 10 days time, my lord. I'm just
Mr. Sen, please for allowed for the 10 days time to file affidavit.
So there is an interim order to continue.
Rejoin affidavit. Just up to 10 days.
Interim order, my lord. There is
interim order, any shall continue the next date.
Lordship. Oblige.
Apply, your lordship.
Item number 10.
Wait, please, your lordship. Your lordship, I'm praying for 2 weeks time to file my affidavit in this matter.
How many times you pray?
This will be the 3rd time, your lordship. It's a new matter.
What's the problem? It's a pension matter?
No, Lordship, arm license matter.
Arm license? Why you not give arm license?
Your lordship, it's not a matter of right that just because an application is made, he will be granted the license.
I think I saw last time he submitted that he goes for business trips and all.
Yes, your lordship.
Then? Yes. How much longer? 1 week?
2 weeks, your lordship.
I think please for the 2 weeks time for affidavit.
Obliged, your lordship.
11.
May it please your lordship, I am representing respondents number 1 to 4.
What instructions do you have?
My lord, we received instructions, but we are seeking some clarifications. So we need some more time. We have already communicated that we need some clarifications. As soon as we receive it, we'll file it.
What's the matter about?
Lordship, here petitioner was appointed as an assistant teacher on a fourth sanction teacher, Lordship. But on an undertaking, he will be appointed as a third teacher if third teacher is left. If someone is left, Lordship.
Yes.
Well, responding number 5
assigned
is the school
principals
management
allowed what? Yes. You've
Responding number
served
5 is the school management committee.
You've served 5.
I'm used to get status to Lordship.
Yes, assigned place for one is allowed. Time? 2 weeks time to obtain further instructions in the matter stop. Petition also to obtain status of service upon respondent number 5. Yes, after 2 weeks. Yes.
Much longer.
13.
Please, your lordship. Your lordship, the affidavit is ready, but we have sent the affidavit for vetting, your lordship. I just need a few days' time, your lordship.
Your lordship.
Your lordship, the respondent have taken so many times, your lordship.
Your lordship, because they had filed an additional affidavit, your lordship. So we had sought for clarifications regarding that additional affidavit.
We'll give you 1 week's time. 1 week's further times allowed. Expected next day it should be on board.
Your lordship, 13 is connected with 14.
Yes?
Item 13 is connected with item 14 also, your
Item
lordship. 14, your lordship.
together next day. 14 is complete.
Hearing, sir.
It's for hearing. Okay.
Much obliged, Lordship.
Hearing. Item 15.
Okay. 13 muncul, 18 muncul. Yes.
Look,
Where are
sir,
we this matter?
this case has become very interesting now. Very interesting point. Now, well, what has happened here? Lordship, the impugn order, which is challenged by my learned friend, the special court has come to a conclusion saying that the award is on the basis of an agreement. Now, my lord, if the award was on the basis of an agreement, if it was a consent award, as per the LA proceedings, it is called a consent award. If it is a consent award, my lord, I cannot even file a reference. Now, Lordship will see my claim petition. My lord, I had not gone before the special court saying that the award is a consent award. I said that I was not paid adequate amount of compensation. So now, my lord, if I argue that the orders of the court is correct, and my lord, that the order has come in relation to agreement, then my lord, my reference goes. So that I'll fairly consider, my lord, being an officer of the court, it is my duty to bring the right proposition of law. If the award is on the basis of a consent between the parties, there is no question of going to the reference court and agitating the matter. So now, my lord, the only thing remains before this, my lord, this forum, my lord, my humble prayer is, my lord, it has to be sent back, remanded back, because the reference has never been answered. And my lord, the reference court is duty bound to answer the reference.
Yes.
Lord, as far as the appeal is concerned, my lord, we are aggrieved by the part of the order which has been wherein, my lord, the court has granted an amount of rupees 7,03,365 rupees to the claimant, my lord, which they are not entitled. So we are only aggrieved by that part of the order. Therefore, my lord, the state has filed this appeal. This is my appeal, my lord, that has been filed by the state, wherein, my lord, now the claimant herein, my lord, claiming for a remand. If they are aggrieved by the order, they could have definitely filed for an appeal against the order, my lord. Now this is the appeal of the state. Whether in this appeal, my lord, whether the as requested by the learned friend, whether the case can be remanded.
Let's go to the law. Let's see. Now, whether it is a consent award.
No,
Some people regard some
it is not.
suppression.
It is not,
a
my lord.
consent award.
It's
Well,
not
the
consent
reason
award.
being, my
It is
lord,
not, my lord, because the agreement which has been enclosed even in the claim petition, my lord,
Undated.
the amount of money which has been awarded as a compensation, it is not on the basis of the agreement. Now we have already enclosed the copy of the award here. That is at page number 60, my lord. It shows page number 60, my lord.
60.
60.
Yes.
Now, my lord, this shows, this is the award statement. This shows that collector, my lord, it has determined the award. It is, this award is not on the basis of the tripartite agreement as has been claimed by the claimant, my lord. And when the collector has already determined the award, he is entitled for the contingency charges, which he is at the rate of 10%, my lord. And these contingency charges, my lord, what the learned trial court has done, my lord, in the order at the last paragraph, if my lord will see. That is at page number 32.
Yes.
paragraph 28, my lord, it says this court finds that since the compensation for the land acquired was based on tripartite agreement.
Then we have to stand by on this point.
Yes, only.
That only this point there was no tripartite agreement.
No, my lord.
Then
here.
Then if it's based on the award of the collector itself.
Yes.
And the amount was paid at that.
That is why.
7 lakh something. And the contingency charges, which is 7 lakh, which is 10% of the
amount
of the awarded amount.
Yes.
That contingency, according to you, it's not a question of the compensation being given to the claimant.
Right.
That should revert back to the collector.
Collector.
That's the only ground.
That is the only ground. Here.
But then if this court is
wrongly held, my lord.
Patent, wrong finding.
Wrong finding, my lord.
Then
that is, I am aggrieved only by this part of the.
See, it says that this court finds since the compensation for land acquired was based tripartite agreement, there was no occasion for the collector to carry out inquiry to determine compensation. As such, deduction in sense of charge 10% is not required. Why is this deduction? This is an addition as per this awarded amount.
What he meant to say, my lord, it should not have been retained by us. That part of the order itself is wrong, my lord.
Total amount compensation 67 lakhs. That means how did this amount total come to 70 then? How much?
No, my lord, it is along with the exigency charges, my lord.
Contingency charges.
Contingency charges.
So but if that was deducted, that was given to you. So along with the contingency, actually the award is 74 lakhs.
74 lakhs, yes.
That is awarded amount.
Yes, my lord. Yes. So this that 7 lakh something amount, my lord, that was for the collector, my lord. This is as per the.
Why it's deducted? Why should a collector get it also? That's for the act.
It is as per the provision, my lord. So this part of the
exercise was involved.
Yes, a lot of exercise is involved here, my lord. And therefore, my lord, the part of the order itself is wrong.
I think what Mr. Gautam submitted strikes a note because he is saying it's not a consent. It's not a consent award. If the consent award is a question of reference. And number 2 is not a consent award. The reference was taken up, never answered. The finding is that there's a tripartite agreement, which was never the case.
Which
so
is not true.
Leave you or him leaves you nowhere.
Which is not true. Yes, madam.
Then.
Therefore, my lord, this part of the order.
No, even the document afresh.
Absolutely, my lord. That is.
He has answered the reference.
Order is wrong, my lord.
Order is wrong. He has not answered the reference at all. So.
Yes. Instead, he should
have.
The
reference is made. Notwithstanding the delay, anything, there's a judgment from this court only.
Yes.
To be settled around 40 cases in July. Where there's substitution and so on and so forth, objections were raised as to time.
In fact, my lord, the duty of the judicial officer, special judicial officer, was to enhance or not to enhance. He has not done that. What he has done, my lord, he has disposed the case and reject. At the last, he said reference stands answered.
You're not aggrieved by that award also.
My lord, the reason why, my lord,
that will have to be noted because that's the reason for consideration is longer. No. Because you can't now, now every goes back, you start raising
Lordship,
demand,
I will submit why, my lord. My lord, once that order was passed, my lord, I was paid a certain amount of money. I took it to be an award. Rightly or wrongly, I took it to be an award. And therefore, my lord, I said I will not further, because I am an old man, I don't want to get into litigation any further. But now, even if that is under challenge, my lord, I have every right to point out before this court that my reference was never answered. What I wanted was enhanced amount of money. I parted with my land, and according to me, my lord,
again, you see, that matter is closed. You never came appeal before this court.
But I participated in his appeal, my lord.
See, you stopped in a way now.
My lord,
so the thing is that if you really aggrieved that your reference is not answered, they should have come for this court and said that, look, I prayed for enhancement, that was never considered, the reference never answered, and so I want. Well, now you're seeking, to roundabout now, to get a remand back and then to re-agitate. No.
Well, if it is remanded,
you make it clear in the order that only this part of the order.
But my lord, if it is remanded back, my lord, at least, my lord, then again, my lord, the reference will not be answered, my lord. If it is only left to that point, my lord.
Very funny case.
No, my lord, the question now which has come before this court.
Decided here only.
Yes.
What has come before this court is, my lord. Of course, my lord, this is a very very peculiar case. I have lordship also appreciates. The question here is, my lord. Now, suppose if lordship remands it back, then my lord, again the reference has to be answered. Now, if it is only sent to that limited purpose, my lord, it will serve no purpose at all. I have made it very clear in the very beginning, my lord. The reason why I did not file the appeal is because, my lord, I was given a certain amount of money, which I at that point of time as a layman took it to be an award. And rightly so, and some amount of interest was also paid. So if I was paid that extra amount of money, I was happy. I would not have agitated. But the fact that they came and filed an appeal, my lord, then I have realized that I have certain rights also. then my lord, if I have not paid that extra amount of money, then my lord, the reference has to be answered. I have to be allowed to participate.
In fact,
Let them keep that extra 7 lakhs.
in fact, here, my lord, in fact, here, this
will not answer the
order,
question or will not go into the question.
this order has to be treated as rejection of his reference, my lord, because at the last paragraph, the court has.
See, the thing is, again, you come same.
Without materials on record, how can you reject my
because
reference?
The finding is what? The finding is that it is compensation for the land was based on tripartite agreement. There's no occasion to collector to carry out inquiry to determine compensation. So if we proceed from that only, but that agreement again is undated, correct?
Yes, agreement is blank in.
Then we have to reappreciate the evidence.
Dated, agreement is dated, but my lord, the amount.
Amount is blank. My lord, if the claimant is aggrieved, he had the remedy with him, my lord, he could have filed the appeal. Now, my lord, can this court even...
He was not bothered
Yes,
anymore. I'm
that
not
is
old
what-
man, he said, I'm not
right.
bothered. But then, now if the
Now, my
window is
lord-
opening, he'll try to get his head inside the window again.
Can this court, my lord, can this
that's the
court,
only thing.
can this court allow something which he is not otherwise entitled, my lord?
How is that not
That is
entitled?
that is one
Whether
question.
Rightly or wrongly, the decision has been made. Let him keep the 7 lakhs, we'll close the matter.
Well, I'm happy with that because if the matter is remanded back, it has to the reference has to be answered.
If it's sent back, then whole thing's opened again. Then his question of enhancement might come again, and then again
amount may be more also.
It is rejected by the special court. Again, will come up here as to why my reference have been answered.
My argument is, my lord,
Your argument is limited only.
Limited,
that
my
you
lord,
felt
only
even
to
wrong
the
that
extent that is
that
wrong,
there was no
not
contingency charge
entitled.
does not arise because there was no exercise
Right.
conducted, in such a manner that he's to be paid the amount that should revert to the collector.
Collector,
correct?
my lord. This amount, my lord, cannot be given to him, my lord, unless there is an enhancement of his order. Unless there is an enhancement by the court, my lord.
You'll avoid, prolonged litigation.
In fact, my lord, if it goes back, my lord, then my lord, in fact, we fairly submit, my lord, the state will have to pay me much more.
Of course.
They'll have to pay me much more
You
because
take
my lord, the
instructions.
reference will be answered.
You've heard what's happened.
Now, my
If
lord,
the courts of the mind to remand it back, it opened the entire proceedings afresh.
That
Then
is-
what happened.
Take a call on that.
my lord,
Take a call.
let me take instruction, my lord.
In the course of hearing Mr. Ensign Condon, I'm an advocate, please be allowed to obtain specific instructions on the tentative view of the court that the matter should be remanded back for answering the reference which has been raised initially. Yes. List after?
After 2 weeks, my lord.
Yes.
Oblige.
18.
Lordship, I pray this matter
Yes.
may be taken up after.
Dr. Mazika is not here.
Lordship, then next week, Your Lordship.
After 1 week, the absence of the learned senior arguing counsel, yes.
Apply, Lordship.
Much obliged, Lordship.
25.
My lord, this is a matter, my lord, where the Nehu, they had floated at NIT, my lord.
Is that same that truck matter?
Truck matters, my
What happened? Where's Mr. Sen?
Coming, Your Lordship.
He's not got the vehicles as yet.
My lord, we haven't got the vehicles as yet. I was the H2.
Yes.
When the H1 had withdrawn, my lord, from his bids, then I was called for negotiating the price. The subcommittee which was constituted by them, my lord, where I had come for the meeting, we had agreed on a price with an enhancement of 10,000 rupees, my lord, per vehicle. My lord, suddenly we received a communication from them later which says that the central committee has rejected it, saying that the enhancement of 10,000 is less, whereas the subcommittee which was constituted by them itself. And my lord, one fact which needs to be appreciated is that the NIT did not have any base price with regards to the vehicle.
No reserve price.
No reserve price was there, and it is an admitted fact in their counter affidavit also.
Where's Mr. Sen? He's coming.
And my lord, over here I was the H1 in for one of the vehicles, which was delivered to me.
Given to you.
Given to me on the same, on that very price which I had quoted. My lord sees Annexure 3, page 37, my lord.
Yes.
My lord, prior to that, my lord may come to page 32. This is the successful bidders, my lord. My lord, the type copy is there. My lord, SG Pathau, he has been disqualified. My lord, entry 4, Elinda Marmanyang Repnar, my lord. I am in the competition with regards to my bid. And my lord, the 3 entries below me, my lord, Sanjeev Trader was the H1 in respect of other vehicles. My lord, page 35.
What is little note, page 34?
My lord.
You made this pencil notings against this. What is the amount?
My lord, these are the base prices which they say that they had put later on. So we have written it with pencil. This is our noting. Though they have not stated, this was orally stated to us at a very later stage.
There's
That
rate given by them. It's 1 lakh, suppose the first one LP bus, 1,35,000 is the rate given by them. What is this?
My lord, in the extreme,
given by you. Now in this matter, you are the L1. But why have they given this 1,80,000 and what is this pencil noting on top?
My lord, page
34.
34. My lord.
Kera, like that serial number 1, okay?
My lord.
ML056975 LP bus.
My lord.
Now, rate inclusive of taxes, your name is given 1,35,000, right?
My lord.
And what's the noting on top 1,80,000? Pencil.
My lord, I'll have to.
What is this?
Mention. My lord, I believe this was the price which we might have quoted it to them. I'll have to see. But my lord will see at the extreme right hand side there are certain more entries which are written.
You can't give deface like documents like this and expect court to.
My lord.
Yeah. And what the amount said.
My lord, be that as been, my lord, on this page 34 itself, on the extreme right hand side, there are handwritten entries written, my lord, with regards to 2,30,000, 1,90,000. My lord, these are the base prices which they say they had later fixated. But my lord, entry number 3.
Mini truck.
My lord, entry number 3 is the mini truck. My lord, I was the successful H1 for it for a price of 1,05,600, my lord. And this truck was given to me, which they later say had a base price of 1,50,000. These were all oral communications, my lord, which were entered over here. My lord, entry number, annexure 5, page 39.
Yes.
My lord, this is the lifting order which they have given to me. Post me depositing the amount of 1,05,600, my lord.
Where's Mr. Sen?
He's on his way, your lordship.
Where is he? He's gone home.
No, your lordship.
Then?
Lower court, your lordship.
Don't say that.
My lord, this amount was deposited by me in consequence.
Okay, fine, that's all right.
To their order.
You took out a truck. Now, since the L1 rates, since the L1 backed out,
My lord.
So since the L2, you made a claim that since
My
the
lord.
L2 now it should be settled with you.
No,
correct?
my lord, I didn't.
Now
I
let's
didn't.
come to your type copy 35.
My lord.
So 105 is that seal number 3.
My lord, this I have already received the vehicle. Apart from this, I was in L2 in 7 other categories, my lord, for 7 other vehicles. No. My lord, I did not stake claim on these vehicles as being L2. It is the NIT itself, my lord, page 26 under section 4, clause 3.
Yes.
My lord, the sealed tenderer should arrange to pay the entire cost of the vehicles within 10 days from the date of issuance of lifting order, failing which he/she will forfeit the security deposit and the offer will be given to the next highest bidder, my lord. My lord, Annexure 6, page 41.
Lecture
6, page 41, my lord.
Yes.
My lord, this is happening after I have been given the lifting order for the vehicle at entry number 3, my lord, the mini truck. Now, since the L1 had backed out, my lord, I have been asked to come and attend a meeting. Negotiation meeting with the negotiation committee, my lord.
Yes.
My lord, this meeting was attended by me. It is an admitted fact that in this meeting, the subcommittee which they had constituted, they negotiated a price with me, which was settled at an amount of 10,000 in excess of whatever I had quoted and I had become successful as H2, my lord.
Where is that? Where is that? Is it come out anyway?
My lord, in their counter affidavit, my lord. My lord, page 3.
Of their counter.
Their counter, my lord. Page 4, serial number 7, my lord.
Yes.
My lord, 6th line, my lord, para 7. The subcommittee,
This meeting held with the
my lord, the subcommittee in its meeting with the petitioner on 10/3/2023 agreed and recommended the petitioner on a willingness to enhance the price of rupees 10,000 per vehicle. However, the committee in its deliberation had failed to appreciate the fact that even on such enhancement agreed by the petitioner, the price would be below the base rate. That would lead to the incurring substantial loss by the university. My lord, this subcommittee is a committee created by them, which committee had called me, my lord, in exercise of the provisions as contained in section 4 entry 3, my lord, of their NIT. Now, when I had gone, we had negotiated. My lord, initially I had said I'll enhance 5,000. Initially I was reluctant to enhance, my lord, because I was the successful H2 and they have published me as a successful H2. If my prices...
Understood. The thing is that, Mr. Sen, now without quoting a base price in your auction notice, how can you insert you amend the tender clause again subsequently by saying that you don't meet the base price on a subsequent appreciation of what has happened? You're bound by the terms of your own tender also. It's your tender.
Lordship will appreciate one thing, my lord.
Eligibility now, whatever conditions are there, it's not a question of him having breached any terms conditions. Now he's L2 as per clause 3 of the tender document. It says that if the L1 is backs out, then L2 will be given the offer. Offer is given. It's a question of the offer not being made.
Negotiation.
And you think, okay, fine, re-tender. It's understandable. But in this case, you had to consider subcommittee, met the petitioner, settled the rate at 10,000 plus the rate offered by the L2. And now you say that we can't give the trucks because transport department so-and-so rejected recommendation.
Lordship will appreciate here one thing.
My lord, transport department never rejected, my lord.
No, the transport
it is,
department.
they say their own department.
Rate, no, estimate rate, and so they
We
rejected
consulted
the
them,
fines
but they
subcommittee.
are the people, my lord, they can provide us. Now, my lord, here you Lordship will appreciate one thing, my lord. The successful bidder, my lord, number one, backed out. So what has been happened, my lord, there is a central purchase committee, my lord. They are the authority who takes call in the matter.
Then why did you float the tender?
My lord?
Who floated the tender? Who is the tendering authority?
My lord, it was floated by Northeastern Hill University.
University, my lord.
It has competent authority to float tender.
No, my lord, I'm just coming to that. Now, my lord, negotiation, my lord, to him, my lord, a recommendation was made on the basis of a negotiations. It's not that he is the successful bidder, my lord.
He never
By
was successful.
negotiations,
He's an L2 bidder.
Yes.
And like even if you go by your own tender condition without even negotiation, you call him, you offer him at the rate, offer the thing to him, finished.
now, my lord, here who
And
takes
negotiate with the price.
Central Purchase Committee, they are the competent authority to take a call in the matter.
But why you consider subcommittee then?
The subcommittee, my lord, for the purpose of negotiation, your lordships. So
Why
they
did- why did
they have, my lord, recommended just on enhancement of 10,000. This is suitable. You do it. Now, my lord, in my writ petition, your lordship, sorry, counter affidavit, my lord, I have annexed the, my lord, the minutes of the meeting of the Central Committee, my lord, Central Purchase Committee. That is at Annexure 2, page 10. Annexure 2, page 10, my lord. Relevant part, my lord, item number 4 at page 11.
Yes.
One. I'll just.
After thorough discussion, resolved that the quoted item be tendered for high AMD as the price offered second was very low, even after negotiations.
So, my lord, this is the reason. And how we arrived at a base price, my lord, we consult, my lord, the experts, my lord, transportation department, what will be
No,
the
why
price.
is the base price never given in the auction notice itself? It's called reserve price in auction. I suppose this item
lord.
can't go below
My lord,
10,000.
Tender is one thing, your lordships, my lord, that lot of discretion is available, my lord, with the
See,
lot of
whatever
discretion.
discretion is available,
Because
but then you
it's
can't
a-
change tender condition
No, my lord.
after you've completed the process.
No, my lord, it is understandable. Had he been the number one, my lord, successful bidder, it would have been different. But his case, my lord, he is number two, my lord, number one backed out. There is a negotiation here, my lord. And negotiation, it has gone wrong, your lordship. So when it came to the notice of the Central
Why did
Purchase
they agree when they negotiated? That means at that time they should have had.
Well,
a
that
say
has been
to
done by
say
a
that
subcommittee, and they made only a recommendation, your lordship. Recommendations, my lord, and a decision, my lord, all those differences are there. And that recommendation, my lord, we have taken note. Purchase committee have taken note of it. And after deliberations, my lord, they say these are the reason, my lord, we cannot accept this. We cannot go and make a settlement which will incur loss to the university.
My lord, their own counter affidavit, they don't say it was a recommendation. They say it was agreed between me and their nominated committee.
My lord, this is a nominated committee, but ultimately decision who takes, my lord, is the purchasing committee. So matter was placed before the purchasing committee, my lord. After deliberation, my lord, they have found, my lord, these would incur
What
loss.
about the truck you already released to him?
Lordship.
The other truck, why you release it to him then if it's below the rate of your base price? The one is L1.
For that they are silent, my lord.
It has been released?
Yes, entry
It's
number
annexed-
3.
it's annexed that in his decision also. You cancel the entire term process, ask him to return that truck now. All broken down trucks, all 88 model and 90 model, and then
I don't know.
how do
that-
you expect to
I
get
know
this kind of
every
prices?
government now coming up that 15 years old and all will become scrap.
Now how will you run those trucks? The serious vehicles registered 1988.
This lifting order, annexure 5, is for an amount which I had quoted and I was H1. And now, as per their own admittance, it is below the base price.
No, there's a
So,
fault.
as an afterthought, my lord, they are coming up with a base price as an afterthought.
My lord, I have placed the, my lord, minutes of the Central Purchase
You're not
Committee.
going by your facts now. You place some authorities.
Central Purchase
Authorities.
My lord, my lord, I will submit a small compilation. We
No,
have,
you just give authority. Now, what authority you have?
my lord, right now I'm not carrying, but there are.
Got auction and base reserve price, and then like that they cannot change the conditions of the tender document like after the matters or tender process is over.
Oh, my lord, that is
And
we
in
have
the tender,
that is a
they
settled.
already said that clause 3 that we offered to the next one, and they've offered him the negotiation the price agreed, and then they turn around.
But here the only difference, my lord, here it is on negotiations. Now whether that negotiation is justified, who takes the call, my lord? Central Committee.
I don't want to argue with the council, but then like you look at the facts as they stare at you.
My lord, I'll provide the authority on two aspects, my lord. One is that they cannot alter the conditions now, and two, my lord, they have themselves constituted a committee. They cannot go back on the decision arrived by a committee constituted by them.
And you know, I'm not saying anything. Can any other authority sit on top of the tender committee or subcommittee? That isn't of this court itself.
This is not a, my lord, full-fledged. This is not a full subcommittee.
It's like, see, once you agree, it's like setting an appeal. There are decisions of this court, of this bench itself.
No, my lord will appreciate. This is a subcommittee, not a full-fledged.
And
This
this
is
matter is going to Supreme Court and upheld, Mr. Sen, with regard to, say, super authority sitting on top of the recommendation and agreement.
My lord, in fact,
it cannot be super authority because this is a subcommittee, my lord. Not a full.
Subcommittee
This is a subcommittee delegated with certain power.
It's up to you to satisfy this court. You have answered.
I'll try.
My lord, IOCL in Sunita Kumari's matter, my lord, will submit that authority has come down very clearly. If the tender proceedings are not vitiated,
with a notice to, give him citation also, then we'll see. The
Yes,
court
ma'am.
knows what to do. It's only the council to satisfy
My
the
lord.
court that it cannot be done.
Lordship.
Yes. Adam. Yes. Very simple matter, Mr. Kera.
my lord, we'll submit it.
Obliged, man.
Obliged.
My lord, the counsel of the petitioner has already withdrawn from this case, my lord, and my lord, there is nothing left in this case. Maybe disposed of, dismissed, my lord.
There's no representation from the petitioner. Matter stand dismissed for non-prosecution.
Obliged.